Chriswell is with us, and this radio program is intended to be for informational purposes only. The information does not constitute legal advice. The law constantly changes. The information may not be complete or correct, depending on the date in your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. He is Marshall Chriswell. Good morning.
Good morning.
Good to have you with us here
Nice
today.
to be here.
We've been talking about estate law for our last few segments, and you came up with an interesting concept for today: estate planning mistakes of the rich and famous.
Yeah.
I like it.
So, we think about these celebrities and whether it be entertainers or athletes or, titans of industry, and we think that they've probably got it all together, right? And they've got teams of lawyers and financial planners on their side working for them, and you think that, when one of them experiences an untimely demise, that everything's probably pretty well buttoned up.
Yeah.
But like a lot of regular folks, that isn't always the case.
It's something that they have let slide a little bit, just like we might tend to.
That's right.
All right.
That's
so
right.
Give me an example.
So we have Prince.
Okay. Prince
passed away in April of 2016. We all remember Prince, super famous musician. So the Prince's estate, 3 years and counting, is still open.
Wow.
It is still in dispute. Hundreds upon hundreds of legal documents have been filed in the case. Dozens of potential heirs have come out of the woodwork. Tens of millions of dollars have been spent on attorneys' fees and administrators and fees, banks handling the estate. And all of this, or much of it, probably could have been avoided if Prince would have thought to make a will.
He did not have a will?
Did not have a will.
Wow.
Yeah.
Wow.
The estate is estimated, upon his death, was estimated at about $300 million. Since he passed, his music has only gained popularity, so the estate's probably worth more like $500 million at this point. But he had no will whatsoever, and he had no. When he passed, he had no known children. Uh-huh. Now, since that time, we have many folks who think that they are
claimed to be children of
Prince's children. But yeah, no will. So you can, within a state of that complexity, all of the intellectual property rights, as well as all the other types of assets that Prince owned, you can imagine how complex and how complicated it's been to administer that estate without any instruction left by him. Yeah. So that's the number one lesson that you can learn is make a will.
In his case, the big mistake he made in his planning his estate was not having a plan.
That's right.
Yeah.
That's right. I guess he thought he was going to live forever.
So swing that back to Joe Average like me.
Right. Absolutely.
Yeah.
So even if you have an estate that's not worth $500 million and is extremely complicated, everybody needs to have a plan. An interesting thing is in Prince's estate, when it's all said and done, over 50% is going to the government.
Oh yeah,
yeah. About 56% will be the tax rate because he's taxed federally as well as in Minnesota. So there are all types of pitfalls and problems that we can avoid by doing some proper planning, even for average Joe.
Okay, so there's Prince, and that's his situation. Give me another example.
Sure.
I like this.
Yeah. So, Robin Williams,
Okay.
tragic story. Obviously great comedian. Committed suicide a couple years ago, and he had Robin Williams just prior to his death, he had updated his estate plan, and so he thought he had things in order. Unfortunately, he didn't pay. There wasn't enough attention to some of the details. Robin Williams left behind adult children from a prior marriage, and he also left behind his then wife, his now widow, And his plan was that his widow would have a life estate, meaning that she would have the right to live in their marital home for as long as she lived, and then everything would eventually be inherited by his children. Okay. Unfortunately, he did not include in his estate plan, he did not specifically say what would happen with the items, the personal property, the tangible things, the stuff that was in the house where his wife was given permission to live for the rest of her life.
So basically, she got a house, but nothing in it.
Well, and that's where the fight is, and it continues. And most of it was sentimental items, some collections that he had. He had a collection of graphic novels, for instance, some other things that weren't necessarily super valuable in terms of monetary value, but they were sentimental items that weren't accounted for in his estate plan. And his widow believed that they belonged to her since she was allowed to live in the house, that she should be able to keep the contents and do with what she wanted. And the children thought, since they were the ultimate residuary beneficiaries of the estate, that they belonged to them. And they both had legitimate arguments, and they couldn't work it out.
In this particular case, unlike the Prince case, where there wasn't a lawyer involved because he didn't have a will, it seems like his lawyers did not do the necessary things in order to advise him, and that's the key role of the attorney, is to make sure that all the issues are covered with the client. Is it not?
That's right, and we don't know what happened in those conversations, obviously, with Robin Williams and his attorneys when he was drafting the will. I know sometimes when I broach these kinds of issues with clients, they say, "Well, my family gets along pretty well, and that they'll work that out themselves." So sometimes it's as much the client as it is the attorney. But the takeaway from the Robin Williams situation is you want to think about everything. You don't want any assets that aren't included. Nothing that's left out there hanging whenever you create an estate plan. Nothing that's ambiguous, because ambiguity gives rise to conflict.
Yeah, absolutely. All right, so make sure that everything, all the proverbial T's are crossed and I's are dotted and everything is accounted for.
Right.
Okay, we have time for another one. We're talking about estate planning mistakes of the rich and famous. What you got for us next?
Next is another famous musician, Tom Petty.
Okay.
So Tom Petty passed away in October of 2017. His estate is nowhere near resolved at this point. Again, we have a widow, and we also have children, his adult children from a previous marriage, and they can't seem to get along. And the problem here, Tom Petty did an incredible amount of planning. He had trusts set up, and particularly a business trust to handle the intellectual property, all of the music that he created. But there was one sentence in the trust that was a bit ambiguous, and it's caused a lot of problems. And it said, okay, it was talking about, okay, who has the authority to manage the trust? Who has the authority to decide, whether we're going to release new albums or put music on online streaming services or whatever type of management needed to be done. And he had his widow and then the two adult children, and the trust said that they were entitled to participate equally in the management of the trust. And that was it, just one sentence. Okay. It didn't say how much power each one of them had or anything like that. So his adult children have taken the position that there are two of them and only one of stepmom, and so they can overrule any decision she makes.
They've got the 2/3 majority.
That's right. And stepmom says, well, no, that clause said that it meant that it needed to be a unanimous decision by all of us to release any new recordings or anything like that. So they're locked in a legal battle over the management of this intellectual property, the music, which is a huge asset of the estate, obviously.
Yeah.
So the takeaway from that, number one, it's ambiguity again. There was certainly that could have been spelled out a little bit better as far as how the business was going to be managed. But also the takeaway is proper business succession planning. If you own a business, and we're again take it back to average Joe, you own a plumbing business, an electrical contracting business, a retail shop, whatever it is. Don't just assume that your family is going to know how you would want that to be managed or dissolved or whatever your plan is whenever you're gone. Things need to be spelled out specifically, and there needs to be a lot of communication between the family members as well.
Yeah, my goodness. That's fascinating because, as you said when we started this segment, these are things that you think, okay, they've got a lot of money, they can hire the best attorneys, and they can make sure that everything is absolutely proper. But if you leave just a little bit of a crack of uncertainty, then someone can take advantage of it, or just from a legal standpoint, that uncertainty does create legitimate problems.
It does. And, in that Tom Petty example, I mean, there's so many ways that you can, that you can spell out who has the authority to make decisions in that situation. But it just wasn't done.
Upshot is that you need to get the attorney involved, and I think a part of it is that the people who are going to be involved in the ultimate disposition of your estate, they need to be apprised as early as possible as well of what this process is. So if they have questions, that the attorney can help to explain things before everything kicks in.
Yeah, I think communication is absolutely vital when you're preparing an estate plan, and you're particularly you're appointing people, you're putting people in these roles, whether it's trustee, executor, power of attorney, healthcare surrogate, all these different roles that you're appointing friends, family members to take care of on your behalf. It's so important to talk to them about it and make sure, number one, that that it's something that they're comfortable doing, but also conveying to them what your intentions are is really important as well, to give them a comfort level and a level of understanding. But it also all comes back to it's got to, if you want something to happen, it really needs to be in the document.
Yeah, absolutely. Okay, so somebody wants to get in touch with you and start planning their estate. What do they need to do?
Give me a call at 724-465-5826. Stop and see me in the Atrium Building, downtown Indiana, or go online to www.westernpalawyer.com.
Very good. Thanks, sir.
Thank you.
He's Marshall Chriswell. The segment is called Marshall Law. That was